Hello, can you hear me? I think so. Let me just go to the stream for a second here. Let me just make a quick little adjustment. Wait one moment. I'm just trying to fix my camera. Okay, I think that's my whole face. Hey. I took my time too. So I wanted to make sure everyone knew what was going on. Let me pop up here. Oh my gosh. Okay. I'm not in the studio because I'm dog sitting. So and I have um, like the next forever days off. So I'm sorry if the sound is terrible. I'm sorry if the lighting is terrible. I'm like in the middle of like a pool day, kind of like still debating if it's like warm enough to go into the pool. The dog's behind. You probably can maybe see like her feet. Oh, you can kind of get a little T-girl action. She's down there sleeping. She wants to go outside, but it's too hot. So we have so much to talk about, and I haven't seen you guys in a couple days. I have water. And I know you're like, you're in a home with the pool. Isn't there cups? I don't want to clean anything. So it's just me. I'm sipping. It's hot. But look at this lighting. I didn't bring a single light. Maybe if I try to do this, then no, just full glare. Oh my God. All right. There's been so much that's been going on. Let me send this out to make sure, and then we'll get into it. Oh my gosh. I just got another alert of something else that just happened. So we have things to talk about. Let me just send this to Ray so she knows. I know she'll want to be here. Okay. This morning was crazy, but before we talk about what's happening currently right now in real time since 9 a.m., let's just go back and talk about like closing arguments, how we are feeling since everything happened. How are we feeling? Oh, I know she needs to be here. She's texted me like 7 times since closing and is like, I just need to know. And I'm like, I know, but there's only so much that they could do. I know, Ray. So I don't know what is going to happen, but I'm going to say 85% chance that there is not going to be a verdict today because the jury is still like being active in the deliberations. Can we see this dog? Just fully laid out. She's amazing. So today is active with deliberations. There's not going to be, I never turn off reactions. There's not going to be a verdict today. Maybe tomorrow. Maybe the next day. Maybe 3, 4, 5 days from now. There is no set timeline. The judge will say if things kind of exceed necessity, the judge will sort of be like, if we can't find a verdict, today or in the next 48 hours, we are going to have to call it either a hung jury or a mistrial or something like that, right? We have to title it eventually. So like there is some sort of time frame, but it's not set in stone. There's no like you get 10 hours to decide. So it could be, I mean, they told the jury it was going to be a 6-week trial, and then they hit us with all the nonsensical nonsense. and they constantly told the jury, hey, we're going to be off today, and then you have court tomorrow, or you have no court tomorrow and there's court tomorrow, or you have the whole day off and you don't have this day off, and then you do. It was all a mess. Scheduling was an absolute mess. I thought closing arguments, Alan Jackson was the proper choice. And I thought he did a fantastic job at reminding the jury to ask questions. And if you can't find the answers, the snoring is the dog. And if you can't find the answers from what the Commonwealth has told you, doubt, then there is reasonable doubt. Let's see. I know Raylene is working right now. I don't know. She's going to be so mad if I start talking about it. But Ray, I got to start talking about it. I thought Mr. Lolly just lollygagged through the whole thing. He tried to hit us with the chart. Like, oh, finally, we have some sort of like manageable timeline. But that all should have been handled in a way where if the jury had a question, it's like, I can't quite remember if this thing or, came before this, very specific minor issues that chart could have cleared up. But there are major issues that chart is not going to be able to clear up. There's too big of questions that chart and all of his little happenings are going to try to clear up, and the questions are too big for his timeline. I was straight up bored by that, very unconvincing. It was like he barely cared. Yeah, it was his exhaustion definitely got the best of him for sure. The lack of letting anyone else in to do any sort of questioning. I mean, you saw the defense had 3 active attorneys and Karen. The defense had Alan Jackson, who was like crushing it. Alan Jackson is a very extremely high profile defense attorney. He was Harvey Weinstein's attorney, he's a big deal in like the legal world. Rightfully so. Do I respect all the things that he's done? No, but as a lawyer, you choose that career, and you choose to give everyone the fulfillment of what's in the Constitution, which is, rights, and everyone deserves representation. We should follow Jackson to his next trial. I wonder if we could. His social media is locked. I think he locked it before this trial. I think he probably goes in and locks his Twitter and stuff before high profile trials or stuff like that, or only ever opens it to his friends and family. So I will try to see the things that he's doing next, and if he is on a trial that's streaming, let's stream it. What else? So the defense had Alan Jackson. They had Miss Little, who is, I believe, I don't know. She might be Mr. I. We know it's why. Mr. I and Eddie's partner or lawyer for Mr. I and Eddie. I don't know. She was on the team, but there was 3 of them. Mr. I. There was 3 of them, and we all saw that Lally took it all on himself. I'm pretty sure that any of those other folks sitting at his table were just as qualified or more to question witnesses. I don't have an answer as to why Lally did it. I don't know why he did it all himself. He didn't have to. Clearly, he didn't have to. Okay, let's talk about what is happening today. So the jury left yesterday with the case to start deliberating. And then today they started 9 a.m. They showed up in court, and let's show court as the jury comes in, and then we'll talk about what happened. Oops. Why is it not working? Hello, where are you? Okay. I don't have a monitor today, so everything is like kerfuffled. All right, so this was this morning, and we're gonna quickly catch up to like real time happenings that just happened. But this was this morning. Let's. There we go.
Yay. All persons having business before the law, Beverly County, Justice of the Norfolk Superior Court before the come to you. You are needed, give your attendance, you shall be heard. I say the Commonwealth of Massachusetts. This court is now open, you may be seated.
22117, the Commonwealth versus Karen Reed.
All right, good morning, counsel. Good morning, Ms. Reed. Good morning, jurors. I have to ask you all, including the alternates, those 3 questions. Were you all able to follow the instructions and refrain from discussing this case with anyone since we left the courtroom yesterday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left here yesterday? Everyone said no or shook their hands. All right, with that, we'll send you back out to deliberate. Thank you.
Good, all right, jury up for your call.
Do the accused look nervous?
May be seated.
All right, so counsel, I don't want the jury to have to wait for us for anything today. So you're to stay in the building until 10. I need you back here for the afternoon, no later than 3:30. And you'll be free to leave during the day as long as you can definitely be in here, in your seats, ready to go on 5 minutes notice, okay? So we'll see you then.
All rise for the court, please.
So that was the morning. That was welcoming the jury in. They go off.
Muted.
Yeah, I know. They go off to their deliberation room to deliberate. And then things happened. This is when things get a little wild. So let me skedaddle a little forwards. So what was that? That was just a couple minutes in. Me, boot, scoot, and boogie. And so the things that happen in court between the lawyers and the judge during this process, like right now, are going to be an open court because the jury is not there. And so any concerns, any issues that are coming up are most likely going to be about the jury instructions, the physical paperwork that they have to fill out, and which is exactly what happened. So let's, oh my God, I don't even know where to put myself. I don't know where all this is going to end. All right. Whew. This is crazy.
Judge, we're back on the record on 22117. I believe we have a question from the jury.
Yes, it's simply, good morning. The jury is kindly requesting to conclude deliberations in time to board the bus at 4 p.m. A juror has a long existing scheduling conflict. So I'm just going to simply say yes and send it back.
Yes,
No objection.
that's fine, Your Honor.
Okay. Thank you.
So a juror has something to do probably 4:30, 5 o'clock, and they all chit-chatted about
Can
it.
we mark this, please?
All the jurors chit-chatted about it. And was like,
Thank you.
would you all hate
Do you want
me
the envelope?
if we needed to end at 4 today? I got things to do. Like, usually we're done at 4. And they were all like, yeah, of course. Like, I want to be out of
Thank
here
you.
at
We
4.
will send it back in with you, Officer Delano.
And so the process is they hand it to the bailiff brings it into the courtroom, calls everyone
you.
in,
All right, all set?
All rise, please.
the judge reads it in open court, and they all, the both sides come to some sort of conclusion about that item. Now that is totally normal. And in my opinion, I saw a lot of people on Twitter. I have been online all day. Like, I have been hardwired into this on the internet all morning because I wanted to make sure that if anything happened, I was ready to go. Plus, I'm just so tired. I'm just like, just chill and just be hooked on something. So I've been hardwired in. Uh, there's crazy things that happen. I forgot what I was going to say. There's crazy things that are going to happen. Let me boot, scoot, and boogie to the next issue of the day. Oh, I took them concluding deliberation at 4 p.m. for all of the external life things that they have scheduled, the jurors have scheduled, as not getting a verdict today. I've been reading things online. Everyone's like, oh, they're going to be done by 4. They're going to have a verdict today. I don't think so. And I told Ray, I told Raylene that if we don't hear anything by like 2, there's probably not going to be a verdict today. If we get like the alert, like verdicts in at 2 p.m. or like 1:30, then yeah, cool, they're done, and everyone gets out of here at 4 and everyone goes back to their lives. But it's going to take 10, 15 minutes for everyone to just get back into the room. Then they bring the jury in. Like, that's another, you got 30 minutes there. If they want to be done by 4, they're either not going to push it, all the way to 2, or they're going to push it to the next day. And I think they're going to push it to the next day. From the notes and everything that I've seen on this jury, the activity of this jury, they are going to take their sweet time and make a decision that no one will regret. They are going to make the most well-informed decision that they can about this case. And I have seen that a lot of these jurors have taken this extremely seriously. There have been a couple instances of jurors approaching like the bailiff and talking about other juror activities and all that stuff. So these jurors have taken this extremely seriously, and I do not doubt their ability to come to a conclusion that they feel to be right. I'm concerned about the things that have happened today in court. Let's get to it.
Back to session, you may be seated.
Okay, so we're going to be talking about jury instructions. And I know I skedaddled through the charge hearing, which is how the hearing that covered the legalities and the verbiage of the jury instructions for the judge to charge the jury, which is just giving them the instructions to be a jury and deliberate. They're not being charged criminally with anything. The legal language is very, very strange. I skedaddled through it because those freaking ads drove me crazy. But it is what it is. Those ads drove me crazy. But the jury was handed a couple of copies of the instructions, and one copy will be the fully filled out, signed, delivered, sealed copy that the bailiff will hand over to the judge. And I don't know in this courtroom or in this even just the state, if the judge reads it out. I've seen it in so many ways. The judge will read the verdict, the court reporter will read the verdict, the foreperson for the jury will read the verdict. So I'm really interested to see who will read the verdict. I have a feeling that the judge will read the verdict. I know the judge does have to look over it and make sure that it's fully filled out before we can read the verdict. This happened in the Johnny Depp Amber Heard case where the jury came to their verdict. They filled out the paperwork and everyone came together and they were like, oh, you have to fill this one other thing out. So everyone go back to the and then have to recall everyone back in. So everything has to be filled out to the T. But this is the shenanigans that is happening in court with the lawyers and the jury instruction.
22117.
All right, so why are we out here?
Your Honor, I just saw the verdict forms, and as we discussed yesterday, the amendments the court indicated it would make a.
Oh, no. Okay, I did not say I'd make it. I said I'd think about it. I said I was tired and I needed to think about it.
Can we just go back? I know. Can we just go back? Let me go up top and cover up these faces. Can we just go back and listen to how this conversation started? I don't know how I know this judge is very busy. I know she is tired. I know she is done with this. I know that she probably has a lot to think about from the testimony that she's heard and the facts that she's seen from this trial, from just existing so close to Canton. I know that she has a lot of things to think about, and I know that she's probably not happy. You know, there's not happiness in the air right now, but this is an extremely strange way to start a conversation. Just in general, right?
What is back to session, you may be seated.
22117.
All right, so why are we out here?
Your Honor, I just saw the verdict forms, and as we discussed yesterday, the amendments the court indicated it would make a.
Oh, no. Okay, I did not say I'd make it. I said I'd think about it. I said I was tired and I needed to think about it.
You said before you were tired and you needed to think about it, was you agree that there needs to be not guilty options for subordinate charges under count 2?
I said that it made sense to me, but no, I did not change it upon looking at it because the verdict slip, this verdict slip as submitted to the jury is exactly how it always is in Massachusetts.
I ask you a question. I don't really care how it always is in Massachusetts. I care about whether or not it's appropriate.
It's appropriate.
Different things.
It's appropriate.
Let me make my argument, if you wouldn't mind, Judge, why it's not appropriate. For a superior charge, they have to decide that she is not guilty of the superior charge. And that is the starting point of whether or not she is guilty or not guilty of any subordinate charge, often called a lesser included. Once they decide that she's not guilty of the superior charge, now there's two additional charges that they've been instructed they must decide whether she's guilty or not guilty of. How do they decide that she's not guilty of the first subordinate charge, involuntary manslaughter?
Okay. Anything else you want to say, Mr. Jackson?
I'd like an answer from the court. How do they decide that she's not guilty of involuntary manslaughter on that verdict?
That's their decision to make.
And how do they make it if they don't have an option to check a box that says not guilty?
They don't check the box that says guilty, do they? And then when they go to the next block, they don't check the block that says guilty. And on the top, you're left with not guilty. Okay?
So it's the absence of the check mark that the court determines is the not guilty finding by the jury.
Yes, that's what the verdict slip reads. It reads not guilty. If they don't check block 2, 3, or 4, the verdict slip reads not guilty. Okay? That's how it is, Mr. Jackson.
Well, and apparently that's how it's going to be because of the court's order. That is not how it should be, and it's over our strong objection. They need to see that there is a not guilty option for the subordinate charges. If they come back guilty on, for instance, involuntary manslaughter, that's immediately appealable. They didn't have an option on the verdict form to find her not guilty. It's almost like the court is directing a verdict of the subordinate charges.
Okay. I disagree with you. Ms. Giannetti, you've seen verdict slips exactly like this. Okay?
I actually haven't really.
Have you had no lesser includeds?
No, we've always had lesser included, but I have not seen a verdict slip there where not guilty is not an option.
Okay. I disagree with you. All right. Excuse me. This is funny, Ms. Reed. All right. We're done.
All rise for the court, please.
All right, let's just break that down a little bit because so much happened, right? So this is my thing with like so much happening, so much happened right there. Let me just, there we go. So much happened just right there. It was absolutely wild. Gotta say, I'm with Mr. Jackson on this one. Why not just make it clear? Right. So let's talk about what just happened. Mr. Jackson says, hey, the verdict forms say guilty, 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 check if guilty. There's no not guilty option on these freaking forms. And the the appellate courts will eat that up, in my opinion. Like, if she is found guilty and she goes to appeal this, the appellate court's going to look at the verdict forms and just be like, they didn't have anything else to check. I mean, I'm sure it's much deeper than that. Oh God, to be an appellate lawyer, whew, golly. But could you imagine, like, not having an option? The jury's sitting there looking at this verdict form, like, okay, well, she's not guilty of this one, but so she has to be guilty. Like, am I not supposed to check? Like, so let me pull up. I think I can show it to you. Well, of course I can show it to you, but I think I think I'm allowed to on my computer here. I can't believe I can only have one thing up at a time. All right, let me see this. Okay, this is the verdict form here, and oops. All right, let's see if I can zoom in a little bit. It's so hard to see because I don't have. Okay. So here is the Commonwealth v. Karen Reed. I can't say it out loud. Verdict slip. So this is what the jury looks at and reads and says, yeah, she's guilty or not guilty. So in the above entitled case, we, the jury, say the defense is 1, not guilty. Okay. 2, guilty of offense as charged. Manslaughter while operating a motor vehicle under the influence. Check one or both of the following. Manslaughter while operating a motor vehicle under the influence of alcohol and or manslaughter while operating a motor vehicle with blood alcohol level of 0.08% or greater, guilty of lesser included offense, which is involuntary manslaughter, or guilty of lesser included charge of motor vehicle homicide, felony OUI liquor, and negligence. Check one or both of the following: motor vehicle homicide by operating a motor vehicle under the influence of alcohol and or motor vehicle homicide by operating a motor vehicle with a blood alcohol level of 0.08% or greater. So this is what the jury is looking at. So seeing this, she's either guilty, see, this is where the confusion comes in, because I'm sure that the questions will be, can she be guilty of 1 or 2 and be found not guilty of, like, just straight up manslaughter while operating a vehicle under the influence? Which manslaughter while operating a motor vehicle under the influence, not guilty. I can see why the judges be like, okay, but like, it's not guilty is right up there. And if they're not guilty of the lesser included, then they just don't check it, because why would you check that they're guilty if they're not guilty? I can see it, but I also think it does need to be just a little more clear, or just re-explained to the jury. I don't know. What are your thoughts after seeing it? Yeah, I just think, and this is the unanimous decision of all 12 members. Assuming that it's going to be decided in 2024 is ballsy. I'm just kidding. Could you imagine? The jury deliberates for 7 months. I think it's one thing to say, look, it's always done like this. If it's not I'm so sorry. If it's not guilty, they don't check guilty. But it's another thing to then say, which I think it gets easily overlooked. This.
Okay, I disagree with you. All right,
I don't see.
excuse me, this is funny, Ms. Reed?
Judge would start to not like the jury so much at that point. Yeah. This little moment at the end of this conversation is very strange to me. So Karen is doing something, smiling, laughing, shaking her head, something.
Agree with you. All right,
I don't see.
excuse me, this is funny, Ms. Reed? All right, we're done.
All rise for the court, please.
So when Karen stands up, she does have a smirk on her face. But is it appropriate for a judge to directly speak to the defendant? I don't know if appropriate's a good word. It's due, like they can do it. They can do it. Should they? Probably not. They probably should approach the attorneys and say, Mr. Jackson, does your client find something funny or laughable about the situation? If so, I would like you to remind them the seriousness of the nature of this, case, blah, blah, blah. Admonish Karen through your lawyer. That little remark, it makes it very, what's the word? Do as I say, not as I do. Judge Canone admonished Mr. I, golly, I just physically cannot say that word, and Mr. Jackson for their comments throughout this entire case. And then for her to make those, to make kind of offhanded comments, like unnecessary comments, you good? The defendant can do whatever they want. Like, she wasn't disrupting, especially with her attorneys. Right, exactly. Especially with her attorneys. Right. So, do you need to go outside? Okay. All right. Hold on. Give me 1 second. You have 5 minutes. Too hot for your fat ass. Go on, be good, girl. All right. That's as far as you can go? Yeah, go find your spot. All right. She's just a silly little sausage. So I don't think it was right. I think it was very, what is the word? Hypocritical. Oh my God, my brain. I think it was very hypocritical of Judge there. She is showing her frustrations clearly. I've seen a lot of talk online about her unequal treatment of the sides, of the, allowing Mr. Lally to just lollygag through this entire trial and then basically tell the defense, hurry up every chance they maybe slowed down or took a beat. But Lally took all of the beats. Lally had his own beat solo. Ew, gross. It's very strange how Judge Canone didn't pressure the Commonwealth in the same way that she pressured the defense. Is it because the defense team can take it and they're used to it and they're strong and they can fight back even harder? Probably. Is it fair? No. Defense came out on top despite the judge being unequal, in my opinion. Yeah, and I definitely think the judge is feeling pressure from all angles right now, and I am doing a little bit more digging into anything else I can find about the FBI investigation for you, Ronnie. Trust me. I have like the basics of it, but I know that there's been updates that have come out throughout the trial, and I was not paying attention to any of this, so I'm catching up on anything new that happened. Who are you talking to? But anyhow, that little moment was very interesting, and I think it will probably be one of those like iconic, memorable moments from the trial. It's like remember when the judge admonished Karen for emoting, you know? And to be fair, Judge Canone was laughing before Karen was. Judge Canone was laughing at having to sit down and have this conversation. She was laughing at the defense for being so ridiculous to want a not guilty on each lesser included. She was laughing too. She was just, oh my God, like seriously? Ew, like you want that? Like, yes, we want that. We want the jury to be able to say not guilty or guilty. Those are options that they need. So, I don't know. Golly. Well, are we done? No. Let me put my face up so you don't have to see me scrolling vigorously through this live stream that is just set on the fan until something happens. So, if you want to watch a fan just kind of spin for 2.5 hours and watch like chat go by, that's very discouraging. The chat in these it's monitored and it's moderated, but it's still very much not my vibe. There's a lot of talk about like the people in the audience and their physical appearances and all that stuff, and we'll make little remarks, I like to think that I'm compliment. If I say anything, it's like a compliment or like just a really just silly thing, there's a lot of people who are saying words like sociopath and narcissist and like putting some real heavy stuff on people, and I can't partake in it. I can't. But I do have to say that the Karen Reed subreddit, physical appearance of the audience, I hate people. Yes. And then this is another reason why I wanted to cover trials myself, is because like on my other channel, I did my absolute best to foster like a community that existed for like enjoyment and support of each other. And I know that if you are for one side, the other side, you are going to have negative feelings for, you're going to be like, oh, they look like this and she looks like this and they talk like this and they probably smell like, that type of childish behavior. And I can't do it. I think it's fair to be like, oh my God, she looks great in white. I think it's okay to say, oh, maybe like a little shady remark about a haircut or something like, oh, Like, it's okay, but if you went like blunt, it'd be really, like there's things that you can say about another person that aren't harmful, but actively going out of your way to try to be harmful to someone is very sad. It's sad. You're sad. So your actions are sad, and there's a lot of that. I know Emily D. Baker, who is an icon. She has a really fantastic community of humans, and they can say the things that they want to say, but if it's against the rules, then they gotta go. And I love that. I love that. You could say anything you want to say. There's a place on the internet for everybody, unfortunately. And there's places where people can say just awful, terrible things about people. And there's places where you can't. And like, it's not even like I can't even think about like fostering that sort of like mentality. I'm so like, I'm already tired. It is 1 PM and I'm exhausted. I don't have that type of energy. I don't care that, like, you can't care that much that you call people like terrible, terrible things. All right. This is the next section. Next activity that happened in court. Let me try to figure out where my head should go. Actually, I'm just going to go check on the dog and listen.
Goes back to session, you may be seated.
Judge, we have a question for the jury. It's been marked QQQ for
Okay.
identification.
So, question, can we request the cert report detailing the search performed? So they can request it, but they can't get it. So I'm just going to say you have all the evidence in this case. We'll figure that out. I'll get some language from you. But Mr. Jackson, after our hearing this morning, I considered what you said. I went back and I read the jury instructions I gave yesterday. So I do appreciate the concern about the confusion this might cause the jury.
Apologize.
I think it's easily clarified with the supplemental instruction. I don't think it's the verdict slip. I think it's how they're to follow the verdict slip. So what I've written up, this is a very rough draft. I'll read it to you. I'll take a break and let you consider it if you want, but
she needs to apologize for being mean. That's what I want. I want her to be like, I'm sorry. She's not going to apologize, but she should. But acknowledging that he brought up something that needs to be clarified is as much of as mind you, has happened at 11:50, like an hour ago. Acknowledging that he brought up something that needs to be clarified is as far as he's going to get. So take that as your apology, Mr. Jackson.
And this works out. I received this, 15 minutes ago, and I've been the question from the jury. So it seems a good time. So I was working on this. It seems a good time to bring them in for an answer to that question. And I would say, as long as I have you here, I want to clarify my instructions regarding your verdict as to count 2 of the indictment. As I instructed you yesterday, there are 2 lesser offenses of that crime, which are involuntary manslaughter and motor vehicle homicide, felony, OUI, liquor, and negligence. Therefore, count 2 encompasses 3 separate charges, the most serious of which is manslaughter while operating a motor vehicle under the influence of liquor. In considering count 2, you should first focus on the crime of manslaughter while operating a motor vehicle under the influence of liquor. And if the Commonwealth has failed to prove that crime beyond a reasonable doubt, then you are to consider the remaining lesser included offenses in descending order. The lead charge is manslaughter while operating a motor vehicle under the influence of liquor. If you find that the Commonwealth has proved all 5 elements or proven all 5 elements of this charge beyond a reasonable doubt, then your verdict shall be guilty of manslaughter while operating a motor vehicle under the influence of liquor. If, however, you find that the Commonwealth has not proven all 5 elements of manslaughter while operating a motor vehicle under the influence of liquor, Then you are to consider whether the Commonwealth has proven beyond a reasonable doubt the three elements of the lesser included offense of involuntary manslaughter. If the Commonwealth has proven the three elements of involuntary manslaughter, then your verdict shall be guilty on the lesser included offense of involuntary manslaughter. If, however, you find the Commonwealth has failed to prove beyond a reasonable doubt the crime of manslaughter while operating a motor vehicle under the influence of liquor and the lesser included offense of involuntary manslaughter, then you are to consider whether the Commonwealth has proven beyond a reasonable doubt the five elements of motor vehicle homicide, felony OUI, liquor, and negligence. If the Commonwealth has proven beyond a reasonable doubt the five elements of motor vehicle homicide, then your verdict shall be guilty of the lesser included offense of motor vehicle homicide, OUI, liquor, and negligence. If, however, the Commonwealth has failed to prove beyond a reasonable doubt all elements of manslaughter while operating a motor vehicle under the influence of liquor, and has failed to prove all of the elements of the lesser included offenses of involuntary manslaughter or motor vehicle homicide, felony, OUI, liquor, and negligence, then your verdict must be not guilty to count two.
May I have just a moment?
Yes.
Look at them hugging. Aw.
Thank you, Your Honor.
I like Karen in white,
Yes.
and I like Miss
I-
Little in black.
I deeply appreciate the court's additional clarifying language. I would simply ask for one very simple amendment, and that is
Like it's minor.
at the top of the verdict slip, it says the two words, "not guilty." We would ask that the verdict slip read, "not guilty of the offense charged or any lesser included offense." That's it. And I think that and the court's clarifying instruction would satisfy the defense. Oh, I think, I know it will. That's all we ask.
All right.
I can repeat that if the court wishes.
Hates that, but
So there are some like minor changes we have to make to the verdict slip anyway. Just, it has to be consistent. So the manslaughter while operating a motor vehicle under the influence, the tab needs to, actually, Tori. So there needs to be some
Tori.
physical changes on the verdict slip. Anyway, it needs to be indented. There needs to be a colon after guilty of offense charged. It's not complete. It doesn't have under the influence of liquor. It just says under the influence. So there are some minor changes that need to be made to the verdict slip. Does the Commonwealth oppose the suggestion made by Mr. Jackson, which seems like a reasonable one?
No, Your Honor.
All right, so it will be not guilty.
Mr.
So
Always like,
tell me again how
I've
you want
lost.
it.
Sure.
You want-
Not guilty of the offense charged or any lesser included offense.
I personally, I think that is so much more clear. It's a great way to clarify on the verdict form.
All right, I think the clarifying language that I proposed
Ma'am, these are regular human
important.
beings.
I do too, and I appreciate that. I think with that amendment to the slip and the clarifying language, I think coupling those up is exactly what the defense was asking for. I appreciate that.
So I need to clean, I'd like to send in a written copy of what I just read there. I have a couple of things bolded. I need to fix this up a little.
I've said it through the entire case, but Karen's part in her hair is so indistinguishable, or not distinguishable. It is so distinguishable. I'm very curious as to why is that like it's so
Up a little bit. I mean, it was just
very
done quickly.
specific
The jury's been
physical characteristic, her part in her hair. It's very interesting to me. Very interesting to me.
waiting. Why don't we bring them in? And I will tell them that a new verdict slip will come into them. How's that? I do, though, have to make a finding that the verdict slip as is was proper. All right, so we'll just leave it at that. I'll make the amendment that you want, but that's my finding.
Thank you, Your Honor. Just from a logistics standpoint, once the new verdict slip is prepared and ready,
We all need to see it.
I was just gonna ask, do we have that email to us or something?
Yeah, we all need to see it. I will work with Tori. All right. All right, can we bring the jurors in, please? Oh, I'm sorry. What, suggested language on the cert report?
I'm sorry, Judge.
Any suggested language on their question?
No, I think the court's correct.
All right, before we get into the cert report, I think Karen's part in her hair is so interesting in like a really cool way. I know that we were just talking about physical appearances. Like, I think it's really like I could almost see a witness saying, I knew it was Karen by the part in her hair as I drove by. You know, like I feel like that could have been even a detail because it is so distinguishable. I think that's like a really missed moment. And I know there's like the trial is over, but and like our brains are just going to continue going on. But there's so much like Karen can change the way her hair look, but that part, I think I have a feeling it might be like a little scar or something that has created it to be such like a solid part in her hair. I think it's like, I don't know. Has anyone else talked about this? I've never seen anyone else talk about it. You could see from the back of her head that it was Karen. So if like someone drove by and she's looking she's looking at John and like lights hit her, you could be like, oh, I know it's her from the part. I don't know. There's just interesting. I think it's cool.
In terms of the cert report request,
I think when people have things like that, it's like so much interesting. It's so much more interesting to just have a little something like you got something special. Not that Karen's special. She could be a murderer.
Any suggested language on their question?
No, I think the court's correct that in terms of the cert report request, the court's answer is right on point, which is you are directed to you're directed to review the evidence that's in front of you, and that's it.
I'm just going to say you have all the evidence in this case. We will not give you anything. Okay.
Karen had something to say there. That was interesting. I feel like the defense should have asked for like one moment. Like, can you give me one moment? Because they all, Mr. Iannetti and Karen, had a lot of things to say about the language. There's no cert report. CERT doesn't write the reports. There is no CERT report, so there's no report to get. The jury can request it, but the jury has all of the evidence that was entered in this case. They have access to all of it, and they want something that was not entered as evidence in this case. So that's why it's like, why do you want me to tell the jury? Because you can't get it, one, but like I believe that CERT didn't write reports to begin with because they just kind of found the stuff and it was up to the investigating function, like whichever police service that they were working with, to write the reports about the things that they physically found. They didn't even like take pictures. The police did. They just find the thing. Very interesting. And it looks like there has been some changes.
All right, so jurors, we're in receipt of your question. Can we request the CERT report detailing the search performed? I take this as a request, and the answer is that you folks, you have all the evidence in the case. So what you have is the evidence in the case. You won't be receiving any additional evidence. But As long as I have you here, I want to clarify my instructions regarding your verdict as to count 2 of the indictment. As I instructed you yesterday, there are 2 lesser offenses of that crime, which are involuntary manslaughter and motor vehicle homicide, felony OUI, liquor, and negligence. Therefore, count 2 encompasses 3 separate charges, the most serious of which is manslaughter while operating a motor vehicle under the influence of liquor. In considering count 2, you should first focus on the crime of manslaughter while operating a motor vehicle under the influence of liquor, and if the Commonwealth has failed to prove that crime beyond a reasonable doubt, then you are to consider the remaining lesser included offenses in descending order. So, the lead charge is manslaughter while operating a motor vehicle under the influence of liquor. If you find that the Commonwealth has proven all 5 elements of this charge beyond a reasonable doubt, then your verdict shall be guilty of manslaughter while operating a motor vehicle under the influence of liquor. If, however, you find that the Commonwealth has not proven all 5 elements of manslaughter while operating a motor vehicle under the influence of liquor, then you are to consider whether the Commonwealth has proven beyond a reasonable doubt the 3 elements of the lesser included offense of involuntary manslaughter. If the Commonwealth has proven the 3 elements of involuntary manslaughter, then your verdict shall be guilty on the lesser included offense of involuntary manslaughter. If, however, you find the Commonwealth has failed to prove beyond a reasonable doubt the crime of manslaughter while operating a motor vehicle under the influence of liquor and the lesser included offense of involuntary manslaughter, then you are to consider whether the Commonwealth has proven beyond a reasonable doubt the 5 elements of motor vehicle homicide, felony, OUI, liquor, and negligence. If the Commonwealth has proven beyond a reasonable doubt the 5 elements of motor vehicle homicide, then your verdict shall be guilty of the lesser included offense of motor vehicle homicide, OUI, liquor, and negligence. If, however, the Commonwealth has failed to prove beyond a reasonable doubt all the elements of manslaughter while operating a motor vehicle under the influence of liquor and has failed to prove all the elements of the lesser included offenses of involuntary manslaughter or motor vehicle homicide, felony, OUI, liquor, and negligence, then your verdict must be not guilty to count 2. So I'm going to send in a new verdict slip on count 2 that's just a little bit different, and we have to sort of change we have to indent something and change the spacing a little bit to make it a little bit clearer for you. Okay, so we'll get that into you in the next 10 minutes. All right, thank you all very much.
Hold on.
Court will be recessed.
All right, court is now in recess. Let me just make sure that nothing else has happened since we've started here. Oh, I am seeing some stuff. Here we go.
With back in session, you may be seated.
Judge, we're back on the record on 22-117. Counsel have both had an opportunity to look at the new verdict slip.
All right, so does the defense say the verdict slip's in order?
It is, Your Honor.
Okay.
Thank you.
New slip confirmed.
Okay, does the Commonwealth say the verdict slip's in order?
Yes, Your Honor.
All right, so the verdict slip will go in. Officer Delano, I'll let you do what you're doing. All right, so the verdict slip will go into the jury. I instruct you or Officer Leiden to remove verdict slip for count number 2 from the jury, have the jurors fold it, put it in an envelope and seal it. And we'll bring that in and we'll mark that for identification. I'm also going to send in a transcript of the supplemental instruction I gave this morning. May we mark that? Madam Court Reporter, please. I have copies for counsel if you'd like.
Yeah, sir.
Yes.
Thank you.
All right. So with that, we'll be in recess. And you'll remember that the jurors were instructed that we won't take any questions or verdict during 1 o'clock to 2 o'clock. Okay.
I missed that last one.
The jurors were instructed in the instructions I gave yesterday that we will not take a verdict or a question from 1 to 2. So everybody's free to go for
Thank
lunch.
you.
All rise for the court, please.
Hooray! Let's see. All right, so they are 1 to 2. They are at lunch, and this is real time happening now. So this is, I'm watching this on Law and Crime. The pool cam is from Court TV. So if you want to, I will be watching this. I will be keeping up to tabs with if anything else happens. So let me just get rid of this here. Let me get this out in my ear. Hate those earbuds. Raylene, we talked about so much. So to summarize what happened today, I cannot sit on these stools. I am too tall to sit on a stool. Like the length of like the pegs where your feet go, they're not the right length. So I'm standing. So the oh my God, the craziness. So we started with just kind of like a, hey, what's going on? Then we came to the issues with the verdict form. So the issues with the verdict form for the jury were that it just said not guilty. Literally just a line where you check and then it said not guilty. And then all of the things that she could be guilty for had a line next to them. But the things that she could be guilty for didn't have lines for like not guilty next to them. Like, well, she's guilty of this, but she's not guilty of this type of energy. And there needed to be clarification on multiple levels. And so the defense brought that up, and Mr. Lally doesn't give a crap because he probably doesn't even read it. He probably didn't even look it over. And one of his team members probably said, yeah, it looks good. He probably didn't look it over at all. The defense was like, we need to clarify this. Like the lesser includeds need to have a not guilty next to them as well. And Judge Canone was like, but Mr. I, you've seen these. You've seen it like this. This is how we do it in Massachusetts. And he's like, absolutely no. And she's like, I disagree. It's very strange. She admonished Karen Reed because Karen laughed or smiled or was shaking her head or I don't know. Karen was directly in the view of the judge, and the judge was not happy for being called out on insufficient verdict forms. Insufficient jury instructions. And she recognized probably in that instant and got defensive that there was an issue. So Mr. Jackson's, her argument was that this is how it's always done in Massachusetts. And Mr. Jackson was like, I don't care. This isn't proper. And she's like, nope, it is. And he's like, I don't think so. Can we change it? And she's like, no. And then later in the day, she's like, I made some changes to the jury forms, to the verdict forms. So yeah. Oh, who cares what Lally says at this point? If I don't have to hear him talk again, I'll be happy. I know. And can you believe that we watched the majority of the trial in 1.25 speed? And that's how slow he was. Sometimes people just talk way too slow. And I know I do it too. But I'm also not a lawyer, and I'm also not trying a first 4 week, then 6 week, then 8 week case. Like, speed it up. I also don't care about the weather. So That is that. That is what happened. The judge came back and was like, "Hey, so we made some changes and we noticed a bunch of other issues." So they weren't projecting um a verdict today anyway. With how incomplete the verdict form was and just like jury instructions just in general, like how they were expecting to have at least a day to make all the necessary changes and alterations to these jury forms and these jury instructions and the verdict forms. There was plenty of time, like the entire trial, to perfect this. But it definitely sometimes gets pushed to a last minute situation, especially when it comes to the defense. They're on the defensive for the majority of the trial. And then when it's their turn, it's their case, they go right up back to back with, jury instructions and verdict forms needed to be complete. So, I get it, it's one of those things where it's like, I just felt like we had more time, but it happened that day type of thing. Lolly always lollygagging. He's always lollygagging, always lollygagging. And like the way he sits there, like his shoulders all hunched down. He's like, blah, blah, blah. He looks a little bit defeated. I do have to say, you guys, if you have just watched some or the majority of this trial from me, one, I appreciate it. You guys are the best. But two, I'm not sharing all of the crazy things that are currently happening because I really did want to go into this as a chatty juror. The last couple of days, to be fair, I have done a lot of digging, a lot of video watching, and not like other people talking about this, but like technical videos, couple incident reconstructions. And a resemblance of a turtle in all his ways, which is so funny because Turtle Boy, Aiden Kearney, I think is his name, the man who has written like 500 articles about the Canton cover-up, is like ruining Lily's life. He's like ruining his life and attempting to. I don't think he's attempting to ruin his career, but it's like, is Lolly's career going to be ruined after this? Even if Karen is found guilty, Lolly does not come out looking good in this case. A resemblance of it. That's so funny. There is insanity outside the court right now. Insanity. Probably 1,200 people, There's probably like 1,000 people that are just active, like free Karen protesters, t-shirts, signs, hectic activity, chants, craziness. There's like police who have to like control the traffic, and this is on a day-to-day basis of this trial. As the trial neared its end, it of course got much busier. There's of course Karen Reed guilty protesters as well. There's a lot of activity in the city. There was what was it called? It's kind of like a city hall meeting. I forgot the name of what it was called that happened, I believe last night or the night before. I think it was last night. And after Lucky Laughlin, remember Lucky, who the defense called and was a witness of, the plowman. After he testified, he's like being heralded as a hero by a majority of the citizens of the town of Canton. There's a lot of activity around this case that goes far beyond the courtroom. That little city hall meeting that they had, I don't want to say the little city hall meeting, but the city hall meeting that town of Canton had, it's not called City Hall, it's called something else. And I can't for the life of me remember it, but basically it's like city council type of energy and people can come up and talk. There was chants happening in the room for Lucky. There was, because it was pretty much like there's two options. You know, if Karen didn't leave the time she did, it would have been unlucky. If it's a cover up. I don't mean to share my hand here, but if it's a cover up, yeah. So there's a lot of activity, there's a lot of energy. There's the federal investigation that I will talk about when verdict happens. I'll cover that in verdict because I think I'm gonna go get in the pool. I think we can go get in the pool. The little doggy wants some attention because she gets mad. She's like, "You're talking, but you're not talking to me." But yeah, so those are the shenanigans that have happened this morning. And yeah, when I say just this morning, it is only 1:23 p.m. They are still on their lunch. They will be done deliberations at 4 p.m. today. Oh, hush up. Hush up. That is so rude. Oh my gosh. She's so rude to me. So I'm gonna probably go. I will keep an eye on everything. There could be a verdict today. I don't know. Maybe with these new verdict forms, they might come to a conclusion a little faster to be like, oh, things make sense now. Not being able to get the cert evidence. What is it? Oh my God, my words. I haven't had enough. I haven't had. I don't think I've had enough vitamins today, or the sun is just like draining me. The CERT report, which CERT was the external but still state regulated trooper energy that did the search in the snow, where they kind of chipped away at the snow, looked at the evidence. Their report doesn't exist because they don't write reports. They don't write reports. So the jury doesn't get it. Plus, if it's not in evidence, you're not going to get it because you can't admit evidence after closing argument. You can't admit evidence during deliberations. That defeats the purpose. But they probably thought, maybe something got left out. I don't know. But that's that. I will be keeping an eye on everything. If we have a verdict, I'm going to go live as fast as possible. So turn on notifications. I got to go. I will see if I see you guys later today. We have a verdict, but most likely I'll see you guys tomorrow with a verdict to this case. We'll talk about the federal investigation and possible next trials that we'll cover. I'm pooped. I need some coffee. All right, I'll see you guys later. Bye.